All rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in Russo and Steele, versus Tri Rentals. Our case number CACV 160042. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you wish to do so. If you do wish to do so, you'll need to keep track of your own time at the clock on the podium. Pardon me. Out of respect for counsel, I would ask that all in attendance make sure your cell phones are off so our discussion is not interrupted. We've read the briefs. We've conferenced the case this afternoon. We are familiar with the record, and we'd encourage you to keep that in mind as you present today. Our proceedings are being recorded. Will be posted to the court's website and then onto YouTube in due course as well. So given that, I would ask that as you begin your argument, you state your name and the party that you represent. So with that, Ms. Gilbride, you may proceed.
Thank you, Your Honor. Good afternoon. Eileen Gilbride for the defendants Tri Rentals and Classic Rentals. Self-dealing, self-benefit, taking economic advantage, purposefully undercutting the deal, that's what the claim of breach of covenant of good faith and fair dealing is all about. Every Arizona case cited in the parties' briefs centered around this kind of conduct. Wagon Seller first described it as the duty not to act in bad faith or deal unfairly, and it cited California cases that uniformly talked about honest dealings. Rawlings talked about the duty to play fairly with the insured and said not every breach of contract is a breach of the covenant. If the defendant acts honestly and does not put paramount importance on its own interests, there's no breach of the covenant. In the non-insurance cases, United Dairymen and Air Freight Express, they both had this kind of conduct, which raised a jury question as to whether there was a breach of the covenant. United Dairymen, the jury could find that the Shugs intentionally transferred possession of the cows to get around the contract with the UDA. That created a jury question. And in Air Freight Express, the jury could find that Evergreen intentionally failed to complete repairs on time so that the other party would lose its contract with Air France and Evergreen's sister company could try to steal the contract away. You don't breach the covenant of good faith and fair dealing by just intending to act, as Russo claims. If that were the case, then all breaches of contract would constitute breaches of the covenant, and we know that that's not the case.
So let me ask. There are the evolution, if you will, of the implied covenant of good faith and fair dealing is, it seems, very state-specific. And in Arizona, it has not been a straight line. The cases at times, especially when they just came out, were hard to, at times, to see whether they applied in both the tort arena and in the contract arena. And we're talking about a contractual claim here, right? There's no tort claim for
Correct.
Breach of good faith, fair dealing.
Correct.
And with Dairymen and Air Freight, my recollection of those cases is the court found that the action that you described was sufficient to create a jury question, but I think it stopped short of saying it had to be that. Do you read those the same way?
I read the cases to say this is the type of conduct. Yes, they were not sort of making a broad statement of this is the kind of conduct that we need. That's what this case is for. That's what we're asking this court to rule. That
you want us to go beyond well-established Arizona law and adopt a standard that is, in my view, demonstrably different than what is the current standard that we have now.
I wouldn't put it that way because I think the current law, the current law does require the self-dealing conduct to constitute or raise a claim for breach of the conduct of the covenant.
What I found not particularly helpful in the briefing was the absence of a definition of what you meant by self-dealing. So what do we mean by self-dealing here?
Purposefully undercutting the party's deal to benefit yourself. So one party, in other words, take the Air Freight Express. They purposefully tried to undercut the deal and not complete the repairs in a timely fashion so that the other party would lose the contract with Air France and they could go in and steal the contract.
Okay, we have
steal the other
cases
contract.
that say, for example, there's a breach of the implied covenant where a contracting party exercises contractual discretion
Right.
to exact a benefit or obtain an advantage that that party would not otherwise be entitled to. So what's the difference?
This is not the exercise of discretion case. It's not a bike,
I know that, but what's
bike
the
fashion
difference?
case.
I mean, but what's the difference? I mean, what you have said and defined as self-dealing, if it was prevalent in a case, probably would violate the implied covenant of good faith and fair dealing. I think it backs to Judge Thumla's question. But you're wanting us to say that in all situations, that type of conduct has to be present?
I'm saying that self-dealing type of conduct is what the claim is about, is the basis of the claim. Because if you take out the self-dealing part of the equation, you're left with just a breach of contract. You're not even left with negligence. If we go with what the Raji says, for example, the duty requires that neither party do anything to prevent the other party from receiving the benefits of their agreement. I mean, that's pretty plain vanilla. It doesn't even require negligence.
Help me out, you raise another question that I had about your briefs. You're not claiming that a party to assert any sort of contract claim has to show negligence, are you?
Right.
You are
I mean,
or not?
No, I'm sorry. Right, I'm not claiming that you have to show negligence in order to breach a contract. You can breach a contract.
Well, I think the question is whether you need to show negligence to establish a claim for breach of the implied covenant.
Right.
I think you need to show more than negligence.
Well, but this is the distinction.
Oh, sorry.
Is your argument you need to show negligence plus something, or you need to show something that, as a matter of fact, is a lot more than negligence?
You might not show negligence. You might not have negligence as long as you have the intent, the bad faith,
Got it.
the not playing fairly part of the equation in it. So I guess what I meant to say is that the jury instruction doesn't even require less than that. It doesn't require anything besides a person, the other party to the contract, not getting what they thought they were going to get. It doesn't require any bad faith. It doesn't require any dishonesty. It doesn't require any intentionally undermining the purpose of the deal.
Is that, though, focusing on the intent or the mental state of the breaching party, is that because the phrase good faith, fair dealing is a poor one in this context? Or is it because the case law requires that? And because I'm just reading from Wagenseller, the covenant requires that neither party do anything that will injure the right of the other to receive the benefits of their agreement. It seems to me, with just that snippet, and I understand from your brief it's more complicated than that.
Yeah.
But just that snippet, there's no mental state at all.
Right, and I think the choice of language, that phrase that you just repeated, which is basically repeated in the Raji, is a poor choice of language, and it's been, as you've said, sort of made its way through the cases. But there's no case.
If I agree with you, though, that is a poor choice of language,
Yeah.
that's the Supreme Court's language. We're bound to follow that.
It's Supreme Court's language in
Wagenseller.
But Wagenseller, if you go back and see what Wagenseller cited for that, it cited California cases that uniformly, all of which, I think there were 2 or 3, dealt with honesty in fact and said that you have to have honest dealings with the other side. It didn't say those cases that it cited, and CJS, frankly, all dealt with honest dealings. And the snippet that was taken out leaves out the honest dealings entirely. So Wagenseller, and I think Wagenseller kind of have to put aside just because it was the employment at will situation, and that's a little bit different.
There was a different type of
It's-
relationship. I understand what you're saying, but
Right.
that language has caused ripples in the pond for years since then in a variety of different contexts.
Right. But even causing ripples in the pond, as you say, every single case dealing with a breach of the covenant has this self-dealing, underhanded, unfair, bad faith conduct in it. And so that, I think, that is what sets it apart from a plain breach of contract. They're not the same. They're not the same claim. As Rawlings said, you can have breach of contract and no breach of the covenant, and you can have breach of the covenant and no breach of contract. They're different. They are not interchangeable. And what makes that difference, what separates them, is the underhanded, self-dealing.
Or is it that good faith, fair dealing is a gap filler, that you don't have to show a breach of an express term to show a breach of the implied covenant of good faith and fair dealing in Arizona? Now, that's not true in some states. In some states, you have to tie it to a specific term that is breached, but not here.
But the gap that it fills is the parties expecting that neither side will undermine the deal to benefit themselves. That is the gap that the claim is filling. So it's all tied up in the I deal with you, you deal with me. And yes, we have these express, contractual provisions, but we also expect that you're not going to run around behind my back and do something to undercut our deal to help yourself, because that's what the good faith and fair dealing is all about.
Let me give you a hypothetical, and it is absolutely a hypothetical. Plaintiff and defendant have a contract. Good faith, fair dealing is implied in that contract. Defendant does something that just crushes plaintiff's benefit under the contract, but not to benefit defendant, to benefit an unrelated third party, not self-dealing. Under your view, even though plaintiff is injured in the exact same amount as if it was self-dealing by defendant, plaintiff would have no claim.
Plaintiff would have a contract claim.
Would have no good faith, fair dealing claim.
Okay.
No, I'm asking.
Okay, I think it depends on the facts. It depends on the facts and circumstances. It may be that, and I can't think of a circumstance that would sort of, factual circumstance that would meet your hypothetical. But if there's no self-dealing, if the plaintiff or if the defendant has done something that breaches the contract, crushes the other side, but has not done it sort of in ulterior motive for a purpose to benefit itself, to undercut, the deal, then maybe there's no breach of good faith and fair dealing. It's just a breach of contract.
Well,
the good faith,
but that assumes there's terms that would be breached. There was no express contract claim in this case, right?
That's correct. That's correct.
And so, but from plaintiff's perspective, and that's why I come back to Wagon Seller, it seems to me that the perspective in Wagon Seller was the harm to the prospective plaintiff, not the benefit to the prospective defendant.
Well, and again, Wagon Seller is a little bit different because
I come back to it because that seems to be a seminal good faith, fair dealing case with roots of what's grown into both tort and contract, right?
Right, and I think because Wagon Seller is such a different factual context, I think you go back and look at the cases and the authorities that Wagon Seller cited for that to see what was the genesis of all of that. The genesis of all of that was the parties' duty to deal fairly with each other, not unfairly. That's an important part of what sets this claim aside from a plain old contract claim. And then if you go to Rawlings, again, these are all the insurer acted to benefit itself.
But there we get into kind of a special relationship.
Yes,
vein,
yes.
don't we? Yeah,
Right. And well, it's only a tort because of the special relationship.
Well, but, yeah.
Right, and I think you can put the insurance cases aside because of that different relationship. That's why I keep coming back to United Dairymen and Air Freight Express and the kind of non-insurance cases that said these kinds of conduct are what raise a claim for, or what, get to the jury on breach of the good faith and fair dealing. For sure, we don't have that here. I think that's, I think that's a given. The only thing that Russo has come up with here to show this kind of conduct is that the tents at Barrett-Jackson were reinforced beforehand and they didn't fall down.
Counsel, let me ask you to address if Russo's right on the law, and I'm certainly
Yes.
not asking you
Right.
to concede that.
Right.
Does your sufficiency of the evidence argument still persist?
I suppose if they're right that all it requires is negligence, because there's no even,
Well,
there's,
let me.
that's not their argument.
I still struggle with the negligence concept in a contract breach. But let's say, and I want to hear a little bit more.
they have a
on-
negligence claim, though.
Right, which
Right.
is not, I don't hear you
It's-
challenging
it's
other
not a-
than as the tail of your contract challenge.
Right, but they did intertwine the two. They kind of treated them interchangeably. If you look at the opening and the closing, and all of the evidence was exactly the same.
Understand.
Yeah.
But different legal theories, one's a contract, one's a tort.
Yes.
But if let's say, for example, if the law was such that the instruction given was proper, do you still have a sufficiency evidence argument?
To me, I would say no, just because the way the Raji reads is this is just a breach of an agreement. It doesn't require good faith, bad faith. It doesn't require.
And I understand completely that you're arguing that the
Right.
instruction was not correct.
Correct.
But, okay.
Yeah,
Thank
exactly
you.
so. Exactly so. Getting back to the sufficiency of the evidence, if we are correct in that really breach of the good faith and fair dealing requires no good faith and requires no fair dealing or unfair dealing, we don't have any evidence of that here. There's no evidence that reinforcing the tents at Barrett-Jackson undermined the agreement or what they had to do at Russo. There was no evidence that we had limited resources and that we decided to spend them at Barrett-Jackson and not at Russo. There's no evidence that Barrett-Jackson offered the tri-rentals some sort of bonus if they would, shoot all their reinforcements over there and not at Russo, or that reinforcing the tents at Barrett-Jackson somehow benefited us to Russo's detriment, did something for us that Russo should have expected, that we wouldn't have agreed to if we were truthfully doing our contract. And there's no evidence of any ulterior motive or some economic advantage. And finally, remember this, the factual allegation that gave rise to the breach of the covenant claim was eliminated from the case 2 years before trial. They based that claim in their complaint on, it had to do with tri-rentals relying on a clause on the back of the rental agreement, and the trial court said, no, that's out of the case 2 years before. So they haven't responded to, well, then what was left for the breach of the good faith and fair dealing if that was out of the case. I see I have 2 minutes left. I just want to speak real quickly on the form of the judgment. This was what laid out in our briefs. The judgment just does not track the jury's verdict.
I'm having a hard time understanding why it matters.
Because if we're correct in our breach of good faith and fair dealing, I think Russo's point is, well, then there's no harm, no foul, because they awarded $3.7 million on breach of the covenant and $3.15 on the negligence claim. So same difference. You can be wrong. We can reverse on the breach of good faith and fair dealing and still have a $3.15 million verdict on negligence.
Well, if we vacate the breach of the covenant, then we would order the judgment be modified.
We would need
Vacate
to
the
have
judgment. But if we don't, does it matter?
Well, it doesn't matter if you think that they are correct on the breach of the good faith and fair dealing. I mean, what it allows them to do is just say, well, let's just keep the $3 million judgment because there's $3 million on this claim and $3 million on that claim, which isn't what the jury awarded at all. It's a general verdict. We don't know how much they would have awarded on negligence and how much they would have awarded on breach.
We can kind of figure that out, can't we, though? Didn't they award $3.7 million, allocated fault 85%, and that's the net?
But it's a general verdict. We don't know if, because of the wrong jury instruction, maybe the whole general verdict was twice as much as it would have been otherwise. We don't know how much they awarded on negligence, if they even found negligence. There was no box that they checked for negligence. They just checked.
Isn't that your problem? You could have, did you, forgive me, I don't remember this part of the record. Did your client ask for special verdicts or interrogatories or anything that would require the jury to identify what their decision was on the negligence claims independently?
It was just the box on the breach of the good faith and fair dealing. That was the only interrogatory that was given.
Okay.
And if they were instructed incorrectly and they found that, and there's a general verdict, so we don't know how much of that verdict was for this and how much was for that.
Well, there's one damage number, and
One damage number.
They were directed, I think, to allocate fault only if they found the negligence claim
Right,
approved.
right. But
So-
we don't know what the verdict would have been had they been instructed correctly on breach of the good faith and fair dealing. We don't know how much to allocate for one and how much to allocate for the other.
I thought your argument on the judgment, and I know we're going over
Yeah,
time,
I'm sorry.
was that it was confusing as opposed to that we don't know what the jury awarded.
No, we don't know. Well, the reason that we have to remand for an entire new trial is because it was a general jury verdict. We don't know how much the jury would have awarded without the breach of the covenant in there. And the evidence was all intertwined. It was exactly the same. The arguments
If
were
it
the
was
same.
exactly the same, don't we know?
If it was exactly the same.
In other words, if it was 3.7 million, and I'm using a caricature,
Yeah.
the damage in closing, 3.7 million, why on two different theories?
Because the cases say where the claims are intertwined, the evidence is the same, and we have a general verdict, we don't know what the jury's intent was, what it would have done without the wrong jury instruction. It was wrong as a matter of law.
But
That's
if
what
we
the
can-
cases say.
If we can determine that, there's no mischief there.
I don't think we can determine that. If the instruction was wrong and the evidence was insufficient to support breach of the covenant claim, I don't think you can determine, well, they would have awarded the exact same amount even without that claim.
Perhaps
That's
I'm-
just speculation.
Perhaps I'm misrecalling how the case was tried. I don't remember Russo arguing there are two different damage numbers depending on which theory was applied.
Right. But we still don't know.
Okay,
Thank you.
thank you. Mr. Eckbert.
Good afternoon. May it please the court, my name is John Egbert, and I represent the plaintiff in this appeal. Let me start by taking your, Judge Thoma's, hypothetical one step further. You referenced a situation where instead of for self-dealing purposes, the party undermines the benefits of the agreement in behalf of a third party. But it's also possible that if I have an agreement and I engage in that type of conduct that you quoted from Wagon Seller, that the covenant requires that neither party do anything that will injure the right of the other to receive the benefits of their agreement. If I do that not because I'm going to get anything out of it in terms of monetary benefit or self-dealing, but because of ill will or spite. In fact, I may lose money. It may harm my interest to do it, but I do it because of some other motivation. That's still a breach of the covenant of good faith and fair dealing. I have still undermined and prevented the other side from receiving the benefit of that agreement. The case law says nothing. In none of our Arizona cases, none of them say that it must be motivated. That it does say that it has to be something more than negligence, it has to be intended, which doesn't mean intended harm, just intended to act. But it doesn't say that intentional act has to be motivated by self-dealing.
Or by anything.
or by anything.
That's the thing.
It just has
So
to
far, it
be
doesn't say
intended.
that.
And our law is very consistent, and their argument has been that it has to be self-dealing. And their argument has been that the jury instruction was defective because it doesn't say self-dealing. And because they're wrong on that, then there really isn't anything to this appeal.
Let me ask, the flip side of the question I ask appellant's counsel, if we agree with appellant on the law, it would seem to me that the jury instruction issue, your position would fail as well, as would the sufficiency of the evidence. But if we agreed with appellants on the law.
No, Your Honor, I disagree. And let me just briefly jump to the jury instruction piece, because I think that's an important point, that what they argued below, what they told the trial court was that, quote, defendants are not arguing that the Raji is wrong, and Raji I've inserted there, that's not part of their quote, is wrong or even incomplete as written. It is an accurate statement of Arizona law on the breach of implied covenant claim sounding in contract. They argued that the reason their modification of the Raji, and by the way, they offered the Raji initially, but they argued that the reason their additional language or modified language ought to be accepted was because they claimed that the Rousseau was relying on, quote, unintentional negligent conduct only. That's not the argument that they try to make now on appeal, that the jury instruction was defective because it didn't raise or didn't address the requirement of self-dealing. It's not a requirement, but if your hypothetical was if I'm wrong on that and it is a requirement, do I lose? I don't think so, because the law is clear that you must object to the jury instruction, not just generally, but you must object on the ground that you assert on appeal. And that's not what they're doing here. And I cite to the Musgrave decision in my briefing that says a specific objection to an instruction upon one ground does not raise an objection upon some other ground.
Let me ask, though, upon what reliance can we place on the jury instruction that they submitted, which, from my reading, and I've got the page in front of me, is pretty similar to their arguments on appeal?
It's pretty, well, part of the problem is that their arguments on appeal, they blend in the self-dealing concept, which we disagree with the concept that it has to be more than negligence, which we agree with the concept that it has to be intentional conduct, which we agree with. So those aren't the same things. Self-dealing is very different from intentional.
I understand. Help me.
I'm
Go ahead.
sorry. You're using intentional, I think, in a different way than the defendant is using it. Negligence is one Brady cat. We'll put that aside. But you're saying that basically it can't be something that just inadvertently happens. There has to be some form of intentionality in the sense that it has to be by design, not by just happenstance.
Right. So in our case, an example would be defendants sent a crew out, but the call failed, or the message never arrived to the crew to go reinforce in advance of the coming storm. They made efforts to do that, to fulfill their implied duty of good faith and fair dealing, but it just didn't happen, not just because of negligence or inadvertent. That's not what we're talking about. That would not be a breach of the covenant of good faith and fair dealing. Here, that's not what we've relied on. And for them to argue, as they did below, that Judge, we need to have some additional language in this.
I guess what you're saying is they don't. Your view is that the law, your view of the law in Arizona is that they don't have to. Your client, excuse me, I'm sorry. There doesn't have to be a showing that the defendant actually intended to harm the plaintiff.
That's
actually
correct.
Intended to harm the plaintiff.
It's a different kind of intent. It's just the intent to act or not act.
Yeah, I understand.
Very minimal intent. Yeah. Not that, gee, we really wanted to hurt them. Mm-hmm. And that's enough. And that's what the case law, that's what, the Rawlings decision makes clear. So.
And the instruction that the defense offered was more along the lines of the extension of the thumb, a hypothetical that you began your argument with, which is it's an intentional act, not prompted by an honest mistake, but by some interested or sinister motive, and implies conscious doing of a wrong because of dishonest purpose or moral obliquity, which I don't read to mean merely self-dealing. It's I want to harm this other party, maybe to benefit somebody else or not, but not purely self-dealing. So, I mean, what I understand the argument on appeal to be, well, maybe the instruction went too far, but at least you need to show some sort of self-dealing. So I don't think that the instruction mirrored the argument on appeal. Be that as it may, I'm not sure the case law mirrors the argument on appeal.
Well, Your Honor, I guess I agree that to a limited extent to what you just said in terms of there was part of the problem that I'm experiencing in trying to respond to these arguments is that there's a conflation of the self-dealing concept, which I disagree with completely. I don't think there's any support in the law for, with the concepts of intent, or that there's some, and candidly, most people do act out of self-interest. I mean, that's Adam Smith's theory of the invisible hand. We all act out of self-interest. So it stands to reason in most of these cases, if not all of these cases, people are going to, when they deprive somebody, the other contracting party, of the benefit of their bargain, they're doing it because they think it's going to be better for them. But that doesn't mean, that's very different from saying that it's an actual essential element of the claim.
And that intent, though, is what I struggle with, because if we're, and this argument is helpful on both sides on that perspective, for a express term, you can gleefully and joyfully breach, or just have to breach for something that falls short of a force majeure or something else, and it's still called a breach. If I understand really now, both parties in the good faith fair dealing context are saying there is some mental element or some mental aspect of a good faith fair dealing, and that's help me better understand your perspective on that.
Yeah, so I think that's right. I think that some of those older cases that Wagenseller cited, and I would point the court to the Fortune case, which was the case in which, I forget which state, I apologize, but it was one of the earliest cases that dealt with this concept in the employment context, where the individual earned this huge commission, but the requirement was that he still be employed on the day that he was supposed to be paid it. And so in order to avoid having to pay out that commission, they fired him. Now he was an employee at will. So that, the employer tried to say, hey, I didn't breach any express provision of the contract, but the court recognized that there is an implied covenant, and so you didn't violate the express terms of that at-will employment, but there is this good faith and fair dealing concept, and what you did by terminating him to avoid having to pay that huge commission was that you deprived him of the benefit of the bargain. That's not what you guys anticipated or expected to happen. That's a violation. And did they, and by the way, that's one where they did it in their own self-interest. But even the court there and in Wagenseller, nobody said it had to be that. But it was intentional in the sense that, nobody asked, well, did you do it to harm this individual? Or did you do it just for your own benefit? That doesn't matter. It's irrelevant to the issue, because that's the kind of intent that, Judge Norris was asking me to clarify. Is it the intent to merely act, or is it the intent to, hurt somebody? And it's not the latter. It's only the former.
Well, I'm wondering, does it necessarily require the former? If we look at the implied covenant as a gap filler,
which I think it is, I agree with that.
I have another word for it, but
There you go.
gap filler. It smooths over the parties, any group of parties' inability to think ahead of time of every eventuality.
Okay.
And provide for it expressly. If one party, even by mistake or accidentally, fails to do something that is not an express breach, but necessarily impairs the other's ability to reap the benefits of the bargain, could that be breach the implied covenant.
The only problem that I have with agreeing with that, Your Honor, is that in some of the insurance cases, and I recognize the differences, but
That's a tort.
Yeah, I understood. But in some of those cases, the Supreme Court was careful to say that, if you just, this happened, kind of like the example I gave a minute ago, if they had tried to send out a crew and somehow the call failed or the message never arrived, maybe that wouldn't be enough. That's not our case. But some of those cases seem to suggest that you have to rise above kind of that inadvertent, you didn't mean to cause that, but it happened, and so we're not willing to fill in the gap, so to speak, in that context. I don't know. But again, that's somewhat theoretical, hypothetical. It doesn't apply here in our case. I don't think we have to worry about that because here, I think we do have the not only is there no error in terms of self-dealing and not instructing the jury or failing to prove self-dealing. We did, in fact, prove it. And I think the way we proved it, and this is kind of the backup argument. I don't think we need to get there if everybody agrees that we don't have to prove self-dealing. But if we did, we did prove it. And the way we proved it was by, in fact, showing that in advance of the coming storm, defendants did reach out to the larger and more lucrative customer and go reinforce their tents and their stakes and straps, but didn't do it here for our client. So that's the kind of intent that they made an intentional decision, and because there is evidence that it was bigger and more lucrative customer, there's your self-dealing if we're required to. And keep in mind that all of the evidence, including the reasonable inferences from the evidence, must be viewed in favor of sustaining the verdict. Not the spin that they wish the jury would have accepted, but the actual verdict, which is in our favor. Let me just address very briefly the motion to amend the judgment, because I think it's important that the court understand that what was asked for in that motion was the defendants asked the trial court to amend the judgment because the language of the judgment, they said, quote, makes it seem that the jury awarded plaintiffs $6,845,000. In other words, what they argued to the judge was, you need to fix this, you need to amend the judgment because otherwise there's a risk that they'll get double recovery. But the judgment, as is in the record at record item 841, was very careful to say there's not going to be double recovery. Here's a $3.7 million award. Here's a $3.145 award. They overlap, and so you're only going to get the 3.7 because that's the bigger of the two. And so there was no danger of the reason they asked for the amendment. So unless there's other questions, I know I have more time, but I think the real issue here is that the concept of self-dealing is not part of this implied covenant of good faith and fair dealing, and that should end the inquiry.
Thank you, counsel.
Thank you.
Ms. Gilbride, we ate into some of your time. We'll give you 3 more minutes if you want them. So.
Thank you, Your Honor. I'm not sure I'll need it, but so let me get this straight. If we tried to send out a crew and it didn't happen for some reason, that's not a breach of the covenant. But if we tried to put more stakes in the tent than we thought were required, but it turned out that the wind blew it down anyway, that is enough? I don't get the difference.
I think the difference is, as I understand the record, is that your client arguably favored the big player in the classic car auction industry, Barrett Jackson, over Russo, and that is a form of self-dealing because they wanted to build that relationship and solidify it and not lose it, and they had to make some decisions, and they went with someone else.
And there's zero evidence of that in the record. There were no decisions to make. If we had only a limited number of stakes and we had to choose and we chose Barrett-Jackson, yes. There's no evidence of that.
Well, I think
If
there is
there's-
evidence that a jury could determine that. I've read.
Oh, there isn't. Respectfully, Your Honor, there's no evidence that there was some limiting choice to make, and we had to choose one or the other, and we chose Barrett-Jackson. There's zero evidence of that. The sole evidence they relied on was this. Barrett-Jackson's tenting was 220,000 square feet. Russo's was 200,000 square feet. And that's it. That is it. There is nothing to suggest that we chose Russo or Barrett over Russo in any fashion. There were the exact same number of crew members. There was the exact same people, the exact same resources. And when stakes started pulling out of Russo, we grabbed people off of Barrett-Jackson and put them onto Russo. 35 extra people. We did all of the changes and grabbed them off of Barrett-Jackson and put them onto Russo. That's what the evidence shows.
Was there a breach of contract claim, straight up breach
No.
contract claim at any point alleged?
No, it wasn't. They tried to allege it after the fact, and the judge said no, it was too late. So, no, there was not a breach of contract claim. And in case I haven't made this clear enough in my opening argument, we are not claiming that there has to be an intent to harm the other side in order to have this breach. There just has to be an ulterior motive to undercut the deal to create this kind of claim. And we don't have that at all. Thank you, Your Honor.
Thank you. Counsel, we appreciate your argument today. We appreciate this conversation. You've given us much to think about. We will take the matter under advisement and we'll issue a written decision in due course. We stand adjourned.